All right, are you Dimitri Oliver? And so Mr. Garvis represents Mr. Oliver and has filed a writ of habeas corpus requesting a reasonable bond. Mr. Oliver is charged with murder. It is pre-indicted. There's $1 million bond at the time, and I don't have the file, but I do have the writ, which is number 22-39802. Also, looks like I have a record. I do have a copy of the probable cause affidavit in that application. So, Mr. Gertz, you may proceed.
Yes. First and foremost, it's essentially a cold. So we came around compliance and given circumstances like schedule, not a cold wasted concussion situation.
Raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Oliver.
Mr. Oliver, do you have a $1,000 in cash? Do you have a what are you doing this one? If I want one, I'm going to pay now. $2 a day, so I'm going to some days, so it's $200 a month. And you own your own home right here. North Shore, and you own any other, what do you own? $4. Okay. What do you owe on? How much was given? Inheritance. How much is it worth? And do you own any other major things in town? Bonds, gold, Bitcoin, so that $68,000 revenue any other major sources? I have no further questions.
That's not any questions. Mr. Oliver, what is your criminal history? You have possession of controlled substances, how useful? Are you on probation? Are you convicted of that?
No.
When?
I was 14.
And before you convicted again in 2005. Between 2013 and now, tell the court what type of trouble you
From 13.
That was the evading.
It's not
I don't have any further questions. Any other witnesses?
Thank you.
All right. Ms. Salvino, witness. I will contact Jeff Dudley. Good morning, sir. Please raise your right hand. Do you swear or affirm that this is going to give in this hearing to be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead. Detective Busby, would you please state the full name for the record?
Jeffrey Busby.
How are you employed? Are you a
Pause right there. This is huge. They're admitting that not all the evidence was entered into Cody's back in 2013. 30 to 40 swabs collected and some of it never tested? That's not just a small oversight. That's potentially case-altering. Cody's hits can identify unknown suspects or eliminate wrong ones. So the question becomes, was this a simple backlog issue, or did this delay shape the entire trajectory of the investigation for 13 years? And more importantly, if new DNA hits now, how does that impact probable cause? Eyes.
police officer in the state of Texas?
Yes,
And are you also assigned to detective?
Yes, ma'am.
And are you the detective or one of the detectives who believe investigating? We have termed the whole case for all the
Yes, ma'am.
The judge has reviewed the probable cause affidavit, but based on all of your investigations, validated circumstances, you give the court very brief rundowns as to the facts of this offense and what you think to be an appropriate resolution.
So we learned in 2015 the homicide case. Came out so there was probably and reports made the office. So if I turn this cold case, because we're doing this speak on this, prolonged until the son September of last year. There are three witnesses that are now will come forward, giving the President's call. How it is. Figuring these witnesses, most of them are very scared. I want to come forward, and even after we go through the path. Really what this may.
Mr. Garrett, questions?
Is that concerned physical evidence? These are all options. So there's a lot of evidence for get out see one from the draw. But for that DNA evidence, they could have harmed so you because what happened was soon after murder, after the murder thing, vehicle was disclosed that was still seeable. Okay, 24 hours. The DNA that was found was someone else from the vehicle. So, have you been able to rule out this at all? Well, sure, it comes to someone else other than Charles. Reviewing this case, almost where the case was collected on, there was
Notice what just happened. The defense is pressing on timeline because timing matters in bond hearings. If results won't come back for months, that weakens the prosecution's ability to argue immediate danger or overwhelming evidence. And when the detective says, "I don't have a valid opinion on that," that's neutral, but in court, neutral can quietly benefit the defense. No urgency, no definitive timeline, just uncertainty. And uncertainty is powerful when someone's freedom is on the line.
What's the timeline? I think what is it about? Okay, it's not just I don't know, it was more like
Any other questions? Thank you, Jacob. Just waiting for the excuses and what? Yes, thank you, sir. Thanks for coming down. All right, anything else? No. All right, argument.
Judge Humphrey, for a bond of $1,000 more research, which reform just go out and stop. Try to live with crime and understand the situation in which 13 years later, he's still here. He has situations. Clearly, he doesn't have so
This is classic bond argument strategy. The defense isn't arguing innocence here. They're arguing risk assessment. 13 years later, still living locally, owns property, didn't flee. They're attacking the flight risk narrative. And that Bermuda line? That's intentional. It's meant to humanize him and inject a bit of levity. But here's the deeper legal layer. Bond isn't about guilt. It's about ensuring appearance and protecting the community. So the real question is, does informant-based testimony alone justify holding someone on an extremely high bond in a homicide case? What would you decide?
Judge, I would defer to the discretion of the court in this case. I do recognize that it is 2013 offense and still currently is in the area. My concern is the same as with every homicide case. I'm just asking for into consideration all of the facts presented before you go through the probable cause and my technicality is something that is measured with bonds. Thank you. And I will for the record, I have to judicial notice of court file and review the probable cause affidavit. Based on that, the evidence presented, including some of the facts that I have, date, things like that. I am going to grant the motion or the writ. I'm going to set bond $150,000 and a condition of that bond.
There it is, $650,000, right in the middle of what the defense requested. That tells you something. The judge acknowledged the age of the case and lack of immediate flight behavior, but still treated this as what it is, a homicide charge. Judges often look at precedent in the county, and she even referenced comparable bonds. This isn't random. It's calibrated, balanced. But here's the tension. Does setting bond as high signal caution or uncertainty about the strength of the evidence?
If made, or some conditions of that bond if made, will be that Mr. Oliver be required to wear a GPS monitoring device at all times. And what is your home address? 2290
Willis.
That vote veteran. And then your apartment complex is what address? 4305 Net J. So I'm going to, at least to make the bond for some amount of time, also require that you wear that monitoring device on house arrest. I will allow you house arrest Willis Street House. I will allow you to travel to the Jeanette Street address for any required maintenance and things like that. I would need to know more about this job before I agree to that. Just to with Mr. Gertz. If there's any specific requests, you can get with Mr. Gertz. He'll get back with me. And if I find that they're reasonable, I'll come up with something. And I will make some adjustments to that. But at this point, that's what it is until you talk to him and you get something else. In addition to those two places, you can also go to Mr. Gertz's office for attorney visits. So until further order of the court.
Just may make just one last request. Based on testimony of Mr. Crosby and his making the comment that at one point in time, at least these were concerned, and possibly are still concerned for your well-being. I'll get with the intake division when I take the state back to them and actually file a list of possible witnesses that have no contact.
Yes.
Just tell them about the information.
Yeah, so I will go ahead and order it now, and we'll fill in the blank on those names. But anyone that you know, even now through word of mouth or on the streets, or whatever you've heard, people who were there, who were talking, you are to have absolutely no communication, no contact with them. That's through obviously you seeing them in person, but it's also through messages on any type of social media or trying to be secret with it. It's also through messages to other people. No contact, no communication. If there is any of that, and I find out about it, we'll go to jail with them. Okay, so I'll make sure you follow all of those rules that you know. All right. Thank you.